Okay, today we have the privilege of having Flagstaff City Attorney with us. Since this is our law class, that seemed completely appropriate. Michelle D'Adria has been the city attorney since June of 13, and she has some background, and we'll be telling you more about her background. And the goal here is for you to understand what the city attorney does in a municipal government setting, and also the relationship between the city attorney and the planning department. And we have one of the city's excellent planners with us today, too. So, with no more, Michelle, please, thank you.
Thanks. Hi, everyone. I'm Michelle D'Adria. I'm the city attorney in Flagstaff. I also wanted to share with you a little more of my background. So I have a BA in history from the University of Texas. Didn't know what to do after that. So spent a few years working at Whole Foods Market. And then thought, okay, I could go to law school without going back and getting another undergraduate degree. So went to law school, and I've been a government lawyer pretty much ever since. I had a few short stints in private practice where we have to bill our hours, which is kind of an unpleasant thing. You have to mark your hours every 6 minutes and bill your clients for your time. As a government lawyer, I don't have to do that. I've got clients that I don't have to recruit. The problem is generally way too much work because you're a free lawyer for all of the city's departments. And so while I was at Maricopa County, I primarily worked for their Department of Transportation. Lots of engineers, but also a few planners who worked to make sure that as new development came on, there were sufficient roads and looked at traffic impacts, those kinds of things. Then I worked at Coconino County for 3 years. That's where Tiffany and I first started working together. My primary client there was community development and also public works, so I had both engineers and planners then too. And now at City of Flagstaff, as the city attorney, I have much broader responsibilities than getting to just work with community development, which I really love. But I also go to all the council meetings, answer council questions, and supervise the office, take on any of the issues that get more politically charged, that kind of thing. But my heart's with the Community Development Department. I'm really excited to be talking to you guys tonight. And Tiffany and I will kind of split up the discussion. I'll talk quite a bit at the beginning about what attorneys are doing with planners, and then we're going to share some of our stories. So let me go back now. So Tiffany.
That's me, Tiffany. I have a bachelor's degree in geography and urban studies from San Francisco. After I graduated from college, I actually went into property management for a while, and then I became a permit expediter for a commercial contractor. It was going to be a really hard task of getting a planning job in San Francisco, competing with schools like Berkeley and Stanford. So I decided that I would pursue a master's degree, and I did go to the University of Arizona. Graduated from there, and I got my first job as a government planner with the city of Prescott. I worked for them for about 2 years, and then was lucky enough to move to Coconino County, where I got to work with Michelle. I was at Coconino County for about 12 and a half years. And for the past 2 years, I've been working at the city of Flagstaff, also back with Michelle.
So I think I already told you the main topics. So what is it that attorneys are doing? One of the main things we do is draft or assist in drafting plans and codes and ordinances. Typically the planners tell us what the document should say substantively, because the planners are going out in the community and finding out what people in the community want. And they're also having meetings with city councils and planning and zoning commissions and finding out what the politicians want.
and they'll put together often a rough draft of a plan or a code or an ordinance. Does everyone know the difference between a plan and a code? So, so the plan is a document that's more aspirational. The community gets together and decides what they'd like to see. For instance, in Flagstaff, we have a plan that was done jointly with the city and county, and all kinds of people were consulted. There was something called a charrette where we could all go in and just kind of draw on a big Flagstaff map what we'd like to see. And it had things like more density close to the university and close to downtown, less density out in the suburban areas, and it has little circles for activity centers where we want to have some commercial activity. It has things like a pedestrian shed where the activity is supposed to kind of stay in that area so that people can walk to everything rather than drive. Anyway, so plan is more aspirational. It's just what do we want. A code is the actual law of what you can do on your property. So, so anyway, as attorneys, we're looking at the documents that the planners work on and looking for legal issues and trying to clarify the language. So we're kind of a secondary reviewer. We represent developers in rezoning matters, general plan amendments, any kind of permits that come before the City Council or Planning and Zoning Commission. Often those hearings are fairly informal, but they're hearings nonetheless, and if sometimes there's not a whole lot of attorney involvement. Sometimes planners just present at these matters, but if it's been very contentious, you'll often see lawyers, or if it's a very big development with a lot of dollars at stake, there'll be a lawyer presenting. We interpret laws, all kinds of laws, the code that you may be working under. We interpret case law. That's one of our harder types of things to do, you know, reading the Supreme Court cases and trying to figure out what they mean in a practical way. One of the things I'd really like to convey to you guys as a lawyer who's worked with planners is when you're reading codes and the law, it's really important to understand that those words matter. What happens in court is we argue about what the words mean. And I know as lay people out in the world, there tends to be a tendency to think about, well, what are the words supposed to mean? What did people intend? You know, what was in the last code? You know, what would be practical? But all of that, in a lot of ways, is very secondary to what the words actually say. And so when you're reading your codes as a planner, if you read them carefully, you'll be doing a lot of what the lawyers do, and you'll save yourself some trouble. We educate on new laws that get adopted by the legislature. There's lots of joint education opportunities for planners and lawyers. For years, we've been discussing Prop 207 in Arizona. You guys heard of Prop 207? Okay. Just really briefly, it's a kind of quirky law we have here that froze zoning codes in a lot of ways in place. Because if you want to change a land use law and it's going to restrict people's property rights, then you have to pay them for the difference in value between what the property was worth before under the old zoning law to what it is now under the new zoning law. So in the context, say, of student housing, that's been a big conversation in Flagstaff is how do we deal with the student housing right next to neighborhoods and all the density that could be allowed, meaning, you know, just 5-story buildings next to a single-family home. There's been, I think, a desire in some communities to just say, well, let's just downzone them. Let's make it so they can't have 5-story buildings. They can only have 2-story buildings so that it's not so out of character to our neighborhood. Well, if we did that, then the property owner could come to the city and say, okay, you have to pay me the difference in the value of my property if I could put a 5-story building versus a 2-story building. Who can afford that? You know, we usually don't have that kind of money. Now, there are ways of getting around it, and I'm sure you guys will learn more about that. Over a certain number of years, people lose their ability to complain, and, you know, so although permanently frozen sounds really bad, there are ways of getting around it. But this is a big issue here in Arizona, and we still talk about it, even though it's been, how long, like 7 years even? 5? I don't know.
You were pregnant. Yeah. So it was 8 years.
8 years ago.
Yeah.
And we're still, just trying to figure out how we can respond to community desires without running into those big expenses.
And that's just where I want to pipe up the point here about the Arizona Planners Association, which is an important group if you're interested in being a planner on joining. This group is about, it is our professional group within the state. It's a division or chapter of the National Arizona or American Planning Association. But what's very important about this group is we have our own lobbyist. So we as planners, when we work in the government field, we're not really able to contact and work on behalf of our communities in terms of these legislative issues. There are specific people designated within each community that have that role and position. So it's really important that as planners we have our own lobbyist who's out there fighting for what's right in terms of the legislation that's affecting us as planners. And while Prop 207 was pretty damaging, it was worse when it originally came through. And so, you know, we were successful in lots of ways in amending that legislation to make it a softer blow when it did come along. So I just throw that out there as a pitch. If anybody ever wants to know anything about the Arizona Planning Association, let me know. I've been on the board several times. It's a great organization.
So, yeah. So the current thing that we're spending all kinds of time talking about is the Reed case. New Supreme Court case just out this fall. Talked about a temporary sign that a church put up in order to direct people as to where the church was. Had like an arrow at the bottom and said whatever church it was. This case came out of Gilbert, Arizona, and we've been really lucky because there are people from Gilbert who have been coming to our continuing legal education and our planners meetings to give us background, talk about what had happened at each court level, and basically almost every sign code in America is now unconstitutional. So we're all, you know, we have meetings, we work together, the planners and the lawyers, and even here in Flagstaff, you'll see it on our agenda in the next few months, just reworking the sign code to make it legal. We used to have about 20 different kinds of temporary signs and different rules for all of them. And we may be able to have 2 now, maybe just 1. So it's a big difference, but that's definitely something that we spend a lot of time doing together, is talking about that new legislation and how to deal with it. We counsel zoning code enforcement officers. You know, somebody's got to take that code and try to go out in the community and enforce it. It's a tough job. It gets a lot of attention with the politicians. You have to be very diplomatic, and mostly you need to be right, because it's really uncomfortable. As a zoning code enforcement officer, if you go out and you're trying to enforce part of the code and then you come back and the attorney says, no, you're not reading that correctly. And they've been fighting with that property owner. So attorneys, we try to get involved early. We try to, you know, help and make sure that everybody's on the same page from the beginning. But when push comes to shove, it's usually the attorney who makes the call on what the language means. Sometimes it's the politicians even, if it's that controversial an issue. We try to help evaluate the chance of success and steer everybody the right way. Sometimes it means that we just have meetings in the end and come to a resolution with the property owner that works for everyone and is within the code. We advise planning and zoning commissions, the Board of Adjustment, and city councils. A lot of that is done behind closed doors because of attorney-client privilege. So if you watch a council meeting, the attorney's almost always sitting there silent. We do all our work beforehand. We send confidential memos to council. They know what the law is and the parameters that they can work under whenever they're hearing a zoning case where there's some controversy and we're concerned that they need to know the law. We also then help them with the open meeting law and that sort of thing to just kind of help the meeting run smoothly and make sure they're following their own rules of procedure. And then the other thing we do is litigate. This is the normal thing you expect from us. Most often it's for code enforcement, usually because there's a large incentive for developers not to litigate in other instances. And anybody have any idea what that large incentive not to litigate might be? That's part of it. But I think even bigger is time. They're always in such a big hurry, which I suppose goes back to money, right? They're in a hurry to complete their project so that they can realize the profit. And so rather than spending a whole lot of time arguing with us about what the code means, they want to compromise. And so sometimes that means we don't have a whole lot of guidance as to what the laws mean. You know, the legislature writes it, and if nobody goes and fights about it in court, you know, we just have to use our best judgment and help everybody navigate through without a whole lot of guidance. So a few times we have had to litigate. Again, we help you evaluate your chance of success. If it doesn't look so great, we help come up with a settlement. If it does look great, we may still settle, but on better terms. We handle the everyday requirements of litigation, so we write pleadings, we write briefs, we go to argue with the court. If it gets to a situation where we actually have to go through discovery and prepare for court, then we help the planners get ready for their depositions and also for the testimony that they have to give. Tiffany and I have been through that. We'll talk about it in a little more detail, but we really try to help everybody get comfortable with the process, which can be a pretty uncomfortable process. So hopefully you don't find yourselves there right away. So there's a few kinds of attorneys you'll work with. Some of us specialize in land use, some of us are more of generalists. The attorneys who specialize in land use are going to know what you know inside and out, although they may not know your code, but they'll know all the land use laws. Some of us are more generalists. You know, we can have all kinds of clients, especially in the government work, and in those cases you may be kind of bringing us along. And then we'll have to get up to speed as we, you know, kind of delve into whatever issue the problem is. So the point I want to make here is don't assume that your attorney is familiar with everything in your zoning code or even everything in the law. If you know it, talk about it. We'll be glad. We'll do a better job for you. So
here we are on to the fun topic. Does everybody know what an exaction is? Anybody know what an exaction is? So this is something fun that you'll face as a planner. Let me tell you what an exaction is. It's basically a requirement by a local government. It's something we place on a developer, which either requires them to dedicate land or construct or pay for all of or a portion of things like roads, water, sewer, etc. as a condition of approval. So, for example, I am working with a developer who wants to put in a movie theater. We do an impact analysis on that movie theater. We determine how much traffic it's going to generate, what peak hours, times that traffic is going to hit that particular area, and we determine that there's now a signal required for an intersection. So an intersection that previously just had stop signs is now going to require a lighted intersection. Or they are adding to the potential to need that intersection. Maybe they only need to add a leg or two to that intersection. So an exaction would be us saying, developer, if you want to have your permit, you're going to have to pay for either the contribution that we can attribute to your development, or build it entirely yourself, essentially. So they can be determined on a case-by-case basis, or they can be something that's based on a specific calculation, which is essentially an impact fee. We all heard about impact fees. So in the city, we actually use both. We use exactions as conditions of approval, and we also do what's called a development agreement. So this is essentially how we obtain what we need for offsite improvements. It could be a new sewer line, a new water line, it could be a new well, new tanks, could be a signalized intersection, could be a pedestrian crossing, could be land for a trail or a sidewalk. So there's lots of different things that we do. Most large developments, they're pretty difficult to address and handle all of the different stages. These development agreements also help us deal with the phasing of these projects over time. The city also uses impact fees, but they are specifically only for police and fire. Those are paid. Those impact fees are specifically paid every time somebody comes in and pulls a building permit. So they're a little bit different in the way we use them. The big exactions through the development agreements are used for those overall developments and the big offsite improvements, and then the smaller impact fee, the individual burden essentially on police and fire. They're paid with every building permit. And technically those fees get passed on to the homeowner themselves. Or the smaller home builder. So there's different ways of doing it. I'll let Michelle explain what she likes best and why.
Yeah, I was just going to make sure that I mentioned to you guys that the Juniper Point development is going through this process right now in Flagstaff. We're working on the exactions. I think we're pretty close to agreeing on sewer and water. We're having a whole lot of trouble agreeing on traffic. It looks like it may actually just go to council with two different versions of what happens with traffic. The developers and the staffs, and council will make the decision. That's rare. Usually there's agreement before it goes to council. So it would be kind of a cool thing to watch if you have an opportunity. So that's Juniper Point, and that's around the community college area. You remember our size and all of that?
It's upwards of about 1,200 homes.
Yeah.
I don't, the commercial has changed.
Yeah, I think it's just like 8,000 square feet commercial now. But the exactions are one of the biggest powers that you deal with as a planner. It's expensive for developers. It slows down their project. You spend a good amount of time in meetings negotiating with them. You contrast that with condemnation, where we have to compensate. Here we're saying, if you want to do this, you don't have a right to do it yet. So we can make you guys take care of some of the problems it's going to cause the city's infrastructure. But in the other instance, where they already are entitled to do what they want to do, then if we want, say, some of their property to expand our road, then we have to condemn and we have to compensate under the Fifth Amendment. So condemnation kind of contrasts, and then Nollan Dolan also restricts. And I think I heard some of you guys talking about Nollan Dolan earlier. Yeah. No? Okay, I did not hear that on the way in. Okay. And I'm sorry to preview,
No,
but
no,
it's hard to
wonderful.
talk
This is
about it
wonderful
without
stuff.
doing some of it.
Wonderful stuff.
Okay, so let's see, that's an M slide, right?
Yep.
Okay.
Sorry.
Just checking. So Nollan versus California Coastal Commission. This case involved a dedication of right-of-way. Right-of-ways is sometimes road, it's sometimes a trail, sometimes the sidewalks. It's just kind of a broad term describing different ways people get through other people's properties. So the government wanted the property owner to dedicate some right-of-way through a beachfront property when a residence was being redeveloped, and the idea was to give people access to the beach. In that case, the court ended up deciding that there has to be an essential nexus between what you're asking the person to do and the impact of the project. So there's that case and the Dolan case. So the Dolan case, do I have these backwards, Tiffany, on my facts? I thought Dolan, okay. I see bike path here. So one of them was at the beach.
The other one's at the beach.
The other one's at the beach. Okay. And here we're asking for a dedication of land for a bike path in order to get a development permit. And there was no essential nexus between the bike path and the permit that they were looking for. I don't have these facts of this case at the tip of my tongue. I'm sorry about that, but you may.
They were building a hardware store, I believe, and the city felt that because of the increase in traffic that this store would generate, that dedication of this bicycle pedestrian path would actually help to relieve the traffic. Mm-hmm. And that's why the court did find that they had the essential nexus. But what they didn't find was the city was requiring the dedication of the land rather than the transfer of the easement. Okay. And so that's where they determined that it wasn't roughly proportional. So there's the second
prong. So the rules are what we deal with all the time is the proportionality and the nexus between your exactions. And that can be difficult. Often engineers try to help us with that. They do impact analyses. They look at how much traffic is going to be created by whatever project. They look at standards that determine typically how many trips are generated out of a particular kind of development, and they have all kinds of statistics that they work with to determine, you know, if it's student housing, then if it's within a certain proximity to the school, then there are less people driving and more people biking and walking. So they take all those kind of things into account and come up with this analysis that determines if traffic lights are needed or new lanes of roadway or bike paths and all of that. And that helps us determine this rough proportionality. So there's often a good amount of fighting about how that traffic impact study is going to be done, which set of figures should be used, that kind of thing, because it can make a huge difference for a development if they have to add a lane of traffic versus not adding it. Their profit can really go down, and especially in a situation like we're in now where people may have bought in 2007 or 8 and spent all kinds of money to acquire property, and you know, then the prices went down, and now they're trying to pencil out how they can make profit off their development. If we tell them you have to build a few lanes of roadway and put in some traffic lights, they may just say, okay, well, we can't do that. We can't afford to build this project. Or and then, you know, they may very well try to convince our politicians that the politicians should find a way for the city to pay for those. So that's kind of the push-pull that happens a lot on these projects, and why we spend so much time talking about rough proportionality and making sure there's a good nexus, because like, consider Milton's annoying to everyone in town, right? I mean, it's just got way too much traffic on it. Consider a project that's 5 miles down the road, but people will likely eventually land on Milton because it's one of the roads that they're just likely to need to get to work or to get food or whatever. We have to look at how far they are down the road, and how much can we tell them, you're responsible for dealing with part of Milton, you're responsible for making Milton better. It's so expensive to make Milton better because everything is right up against it, right? And there aren't easy solutions. You've got to buy property. It really isn't easy. So then you get into the arguments of, hey, we're so far away, our people aren't really going to go there. They'll find other ways around. We shouldn't have to pay for anything to be done to Milton. And you argue about that. So now let's talk about some of our specific projects, unless you guys have questions right now. No? Okay.
So this is a project that actually is from Coconino County inside of the city of Flagstaff. It's the Perrin Ranch Wind Farm, which is located off of Highway 64 on the way to the Grand Canyon. It is a 99 megawatt wind generation plant consisting of 62 1.6 megawatt turbines. These turbines are 262 feet tall to the hub, which means that the turbine blade itself comes quite higher as it rotates around. Half of that project is on private land and half of the project is on state land. The Board of Supervisors would not have normally have heard this case because this case was specifically a conditional use permit. It was approved unanimously by the Planning and Zoning Commission, but was appealed by both neighbors and the applicant to the County Board of Supervisors. The County Board of Supervisors, in a 3-2 vote, approved the case after 2 days of hearings, and with the final decision coming at 3 a.m. in the morning. 22 conditions were applied to the case. Most of those conditions were multi-part, so while it looked like there were only 22, there were probably closer to 50 different conditions affiliated with this case. The attorneys and the planners did have to huddle to basically draft all of these conditions, but also how the conditions got muddled at the hearings, both Planning and Zoning and Board of Supervisors. The surprising thing about this is that you'll note that the case was heard February 2011, and the surprising part about this was that the plant went operational in December 2012. And this also included a NEPA review as well as state land permits. And I can share the joy of going through the state land permit process. It usually doesn't take less than 18 to 24 months. They did it in about 6.
Can we ask you again, you said that the Planning Commission approved it?
Yes.
And then who appealed it?
Both. The neighbors and the applicant themselves appealed the case.
The applicant appealed the conditions?
Yes.
Okay.
Oh yeah, so while we were handling the wind farm case, the Planning and Zoning Commission wanted to understand how it would look, where it would be, what kind of birds are out there, what is the actual land look like? Is it rocky? Is it smooth? So the planners got to arrange to take all of the Planning and Zoning Commissioners way out off-road, I think, yes, for part of it, in order to look at these various sites. And there were lots of turbines, so there were quite a few sites to go look at. One of the things they had to consider was open meeting law, which wouldn't necessarily be intuitive. You can't just put all your Planning and Zoning Commissioners on a bus and drive them all out together and let them talk, because the citizens are supposed to be able to hear all their deliberations, and they're not allowed to make their decision ahead of time before they've heard all of the citizens' comments and basically all of the evidence going both ways towards whether it's a good idea to have a wind farm or not. So I had some pretty savvy neighbors and citizens groups who didn't like the wind farm at all, and they actually brought a case to the Attorney General's office that they had violated open meeting law by going out in these vans and looking at the sites. Fortunately, the planners had kept very good notes that could show exactly who went, which day, who drove the van, everyone they picked up. So we were able to defend and show that we didn't do that, but people will often try to use legal tools in ways that aren't necessarily intuitive to us in order to stop the project or make it look like government's doing something wrong. So we were happy it didn't work.
They also complained about us eating snacks at the table.
Oh yeah, I forgot about that. And we went till 3 in the morning.
Hungry. So this is just one condition that Michelle and I probably spent, I don't know, like forever dealing with. So because the citizen group was so involved and the case was approved, they followed this case all the way through construction. Usually after a case has been approved or denied, the public moves on. This one did not move on. They stayed with me through the entire permitting process. And they wanted to make sure that every single one of those conditions was adequately addressed and met, and the files had to be open for them for review at any point in time of day. And again, talking about 50-something odd conditions. So this one was the last sticker. It was a 3 a.m. condition, required the applicant to post a bond to cover the cost of the removal of the farm. Part of the concern is if the technology became outdated, if the owner went bankrupt, what do? We do this on cell towers all the time. We never actually thought of, it figured to do this on this project, but we didn't really think a lot about it. So going to apply this particular condition, and it's the last condition that has to be addressed before the farm can go live. So how do you calculate the amount of a bond for the removal of a wind farm? It's not an easy feat. And so definitely...
No, we had to make it up.
Right, we did. And we had attorneys on the applicant side. I had the county attorney assisting with all of this. So here's what we came up with. So we decided that it would be reasonable to consider the scrap value of the existing equipment on site, the turbines and the 2 substations. Obviously, they're worth a lot of money in order to offset the true cost of removal. We also then had to figure out the value of those improvements, so we asked the applicant to hire an industrial appraiser to determine a value. We then had to consider the depreciation of the equipment over the life of the project. So this complicated matter, so we decided to accept a bond for a specific value for every 5 years. Every 5 years, the bond amount would be expected to increase based on the depreciation of the equipment on site. And
I put that on note at the bottom of yours. There's so many times when you're working as a lawyer, and I expect as a planner too, where you just think, are people going to come out and just stomp on my grave because of something we did in the planning field that really is awful now? Because you think, who decided Milton should work like that? What went wrong there, right? And you don't want to be the one who creates those kinds of issues for a community. And I think, for me, I was really proud that we came up with the idea of every 5 years you have to look at this again, so that if conditions completely change, say, the solar panels get so cheap that they're on every window, then, we don't need these wind turbines anymore, that people living out there aren't having to look at them forever. They will get torn down, and there will be a bond in place to pay for it, even if it's 100 years from now. So.
Right. And there have been issues with other wind farms in California per se, as the companies have changed hands and the turbines have become obsolete. So it was definitely a legitimate reason to have it. It's just, the idea was good at the forefront. We just didn't know how it was going to work out until the end. And it really was the last condition. They were going live because they had to meet a federal deadline for their tax incentives. And there were some definitely sweating it out moments where, basically you're in some ways not really threatened, but you're told it's going to go live whether you want it to or not. And I can shut off the electricity to somebody's house. That's pretty that's pretty far way to go, but I can't really shut off the electricity to a wind farm. So really, in terms of the scale and mass of that project and trying to ways in which we could do enforcement, that's not really an enforceable project. So I knew that it was really of importance that we get to it. And it was helpful. I had attorneys on both sides, but they worked really, really well together. And they helped me both get to what I needed to fulfill the conditions, as well as also look at the public and provide them with the information that I had, what I needed, and that it was reasonable. And I think the bond only was like $1 million, or was it $5 million? I don't remember. This is a good one.
I think you're taking.
Yeah. This is,
okay.
This is super good. So this is another county issue. Cities don't have this. In Arizona, the statutes for counties exempt 6 uses from zoning, and this has actually changed. When I originally started, it was 5. It's now 6. That for sites that consist of 5 or more contiguous commercial acres. And only about halfway through my career did I learn that a commercial acre is actually different than a regular acre. Most important number to know, 43,560 square footage in an acreage. 35,000 square feet is actually what is considered a commercial acre. It's a real estate term. I had no idea about this. Those 6 uses include railroad, mining, metallurgical, grazing, general agriculture, and agricultural composting. Agricultural composting is the one that has been added to this list. So, how do you determine if somebody meets the requirements of the exemptions? Because this is essentially the exemption. This is what it says in state law. These six uses, and as long as they're contiguous commercial acres. So does that mean if I have 5 goats on 5 acres that I am exempt from zoning? I didn't think so. So I'll tell you the case that I generated lots of fun for Michelle on, and she ended up having to prepare me for a deposition, I think about 10 years later after the fact. So this was probably within my first 6 months of working at the county. I had a building permit come in for a building that didn't meet our requirements. When I called them and I told them I couldn't approve it because it didn't meet our requirements, they explained to me that they were a working ranch. So my first question is, why are you applying for a permit? You're not required to. And they said, well, they really wanted a building permit. And so I followed it up with a couple more questions. Well, what kind of ranching do you do? You know, do you have grazing allotments? What are you doing on the property? The person that owned this property actually happened to be a very, he owned a large commercial business in the Phoenix area. He had his own attorney in-house. So when an attorney is processing somebody's small building permit for them, you know that something is up. But maybe I was a little too young and naive at the time to truly catch on to that.
So let me make sure I understand. So exempt from all zoning?
Yes.
So
And
building height,
subdivision.
building size, uses?
So that's the catch.
Okay.
Okay, so the catch is, and I'll get to why it helps when you work with them and when you don't work with your attorney, but that's the catch, is that the use has to be railroad, mining, metallurgical, grazing. So it's any building that is affiliated with grazing.
Okay.
So it could be a bunkhouse, it could be housing, it could be fencing, it can be barns, those kinds of things. But
It can't be a hotel.
It can't be a hotel.
Okay.
It can't be a gas station.
Okay.
Can't be an RV park. So it does really have to be a use that's affiliated with one of these exemptions. So they were building, it was kind of a barn type structure, and I can't remember all about it. But anyway, so I went in one day and I sat down and I talked with my boss and I said, so what really makes it exempt? You know, what's that clear cut, you know, it's exempt, it's not exempt. So this person had horses and donkeys. They didn't even have cows. So to me, that's not grazing. I mean, to me, this is about an agricultural product. You're raising a product. That the whole point of this is to promote these types of uses. You know, everybody's heard of the 5 C's of Arizona: citrus, cattle, copper, cotton, climate. So, you know, a lot of these kind of fall within those those seas of Arizona. So that's kind of where I was heading. I talked to my boss about it. He kind of said, you know, generally you would be expecting that this is somebody's financial, this is their business, they're making a financial. So I wrote some fabulous letter to the attorney of this property owner, and I came up with some great legal finding, essentially, that basically said, in order for you to qualify as a working ranch, then you need to show us that you financially have this many head of cattle. You know, I can't even actually remember because it was so long ago. The property, things elevated beyond me as the baby planner at the time, and things went on to the attorney we had at the time and our director, and they finally just gave in to this person and said, okay, you're exempt. We'll give you agricultural exempt and build what you like. So he did. He built a bunch of stuff on the property. He had a bunch of manufactured homes on the property. And then one day he filed a subdivision plat with the Arizona Department of Real Estate.
Sorry.
So he didn't submit the subdivision plat to Coconino County. He submitted it straight to the Arizona Department of Real Estate. And basically what he showed were a bunch of triangles throughout his property. His property was basically a section. So he showed a bunch of triangles. And each one of those triangles was a place that you could buy, sort of like a condo, sort of not. You didn't actually own the land, but you bought in common to the ranch, and by buying this triangle, you were part of the working ranch, and you were then also exempt from zoning.
Sure.
So it was actually pretty good.
Yeah, actually, and they talked about running cattle through the rest of the property, not in the triangles, but all the rest of it. So, you know, claimed it was a working ranch. I mean, what it really was a very high-end subdivision where they were going to have some, you know, sideline rodeo type activities.
And it was a lake and fishing. And so all this time, all he'd really been doing is getting the property ready. Mm-hmm. But I had been out of the loop on all of it. So of course, when the subdivision plat comes around, the Arizona Department of Real Estate put a big disclaimer on the front of their public report that said, Coconino County may not issue building permits on this. So of course that initiated a lawsuit. My boss was named in the lawsuit. They believe they filed it to him at his personal residence. Mm-hmm. They named both him and his wife. Yeah, that was very convenient.
Wow.
And all of these different things started coming into play. And then I remember one day the AG's office, I think it was the AG's office, called me. I don't know why they were involved, maybe representing the Department of Real Estate. Right. They call me and they say, I have this letter that you wrote in, what year would that be? Right. 2001. And I'm like, oh, okay. I don't quite remember. Could you refresh my memory? So they send it to me, and I'm looking at it. I said, yeah, I wrote that. And they were like, well, where exactly, what case did you get this finding from? And I was like, none. I made it up. So that the end run became a difficult part of the contention of this whole lawsuit is this original finding that I had made, even though it was kind of thrown out because they gave him the exemption and then it was only later, but they brought that original issue all the way back up. So therein lies the rule. When you first start out, you might think you're really smart and you think you know the law and you think you got it down. Always run it past your attorney. It's always the best way to go. That's what they're there for. That's what they help us with. I didn't have Michelle at that time, which is unfortunate. We had actually switched attorneys. I don't know if you guys have met Bill Ring. He had been our attorney at the time. He left to go into private practice, so we were sort of in between attorneys at the county at the moment, and I was relatively new there as well. So, but Michelle had to then, I think also 10, 11 years later, prepare me for a deposition. Right. That was over an hour long, mostly asking me about that letter. Right. So.
Yeah, we had so many documents in that case, and her boss at the time did an amazing job of basically memorizing everything he had said in the past about this situation to get ready for his deposition, and then did a really nice job of not looking angry while going through it. But, you know, for a while, you know, we were concerned. It seemed like such a ridiculous situation to say that this thing was not a subdivision, just because you put a triangle around it and there'll be 3 or 4 cattle roaming through. You wouldn't think that would work, but it was nerve-wracking for a little while, but we got a good ruling on it.
Yeah.
We got out of it on motion practice. It went up to the Court of Appeals because these guys had more money than sense. So, you know, we spent a lot of time on it, but in the end, yeah, it all worked out.
But then the last part of this, I can tell you what happens when you do it right. So before I did leave the county, one of the things that I was able to do was to set the code right, to fix it. So the zoning code now has a special section about exemptions, and now we require that you apply for a certificate of exemption. And it follows the Arizona Department of Real Estate or Revenue's agricultural manual. So essentially you can get property tax relief if you are a working ranch or one of these projects. So they have pretty good, sufficient, detailed parameters that you have to meet. So in working with the attorneys, they really felt that that was something that we could rely on, that those were a basis of fact that we could work with to clarify whether something was agriculturally exempt. The other good part about that is with the certificate we were able to clarify that if the use that's exempt is to ever be extinguished, that all of those structures then have to be brought into conformance. Anything that was built out of conformance or out of code then no longer has that exempt status.
Because they lose their exemption.
Yep. So it's a way to regulate it, it's a way to know. It's a good thing for code enforcement, especially in a county that's as big as Coconino County. It's the second largest landmass in the United States. So you know, it's a really, you know, 3 paragraphs, but it's the best piece of code that I felt that I could leave behind, and so other people don't make the same mistake that I did. So at least we fixed it.
Yeah.
Did they have to tear down the subdivision?
They never actually, well, I don't know what they did.
They didn't actually get to build it. He'd started, he had his own house, and then there were a couple houses that he claimed his kids were eventually going to live in. So it ended up looking kind of like a compound, but it doesn't look like a subdivision. But, yeah, so that was good.
He was advertising the sale. So I would have people call and ask, why won't the county issue a building permit? And I would say, you need to submit that to our attorney, because we were in an active lawsuit.
But it was funny going out there because they talked about they were going to have all these cattle, and we kind of knew that the more cattle they had running through it, the harder it would be, you know, for us to say that the agricultural exemption doesn't apply, especially since we had no language indicating what qualifies for that exemption at the time. So we go out there to look, and we didn't see much cattle, and we said to the guy, well, where are all the cattle? Oh, well, they're in there. You just can't see them because of the trees. So, you know, it was kind of ridiculous, you guys. I don't think he ever thought we'd actually go out and look. And so, anyway. You want to take Amy?
Okay.
I'll take short too.
So the Coconino County zoning code actually had a little line item for exotic animals. And it said that you could have exotic animals with a conditional use permit. The code wasn't really great on describing what an exotic animal is. And so technically an exotic animal would be anything that's not native. Okay, so we have a lot of ostrich farmers. People raise ostrich for meat. They're short-term, and so over the years we considered them to be exotic. We made them go through a conditional use permit because typically ostriches, they're very big animals. They move really fast, but the land carrying capacity for an ostrich is higher than it is for a horse or a cow. So we would typically allow people to have more than the normal agricultural animal count. So it was a good thing to regulate it through a conditional use permit. Never had any problems with that. So one day I pick up the phone and I've got a call from a neighbor, and the one thing you should always know is there's always a backstory behind any complaint. If somebody's picking up the phone to actually make a complaint, there's something else going on. So I get a call about these people who have some emus and a llama and I don't know, something else like a horse or a donkey or something. It's out near Lake Mary. What they've done is they've installed, you know when you go to a feeding zoo and you can put the quarter in the machine and get the food pellets to feed the animals? So they put one of those on their fence, on their corral fence. So of course people are stopping and getting the food and feeding the animals. Well, they're causing a problem, you know, there's no, this is a dirt road, so they're causing, you know, there's nowhere for them to park, they're causing traffic related issues. There's a lot of people that go out there in the summer for recreational purposes and they're thinking, great, yeah. So I'm like, well, that would be a problem. So I forwarded on to our code compliance issue. Well, the big issue that I wanted to stress was the device for the food. Well, they promptly took that down.
Oh, okay.
But the complaint didn't stop from there. The neighbors were still perturbed. There was some other issue going on. I think one of them had tattled on another one and somebody had lost their job at the lodge. I don't know. So, but that's where it went into code compliance. Michelle got to take it over. But essentially we were telling them, you have emus. I've learned all these crazy things. They're erratic, like an ostrich. It needs a conditional use permit. And they fought back, and they fought back hard. And we did actually lose that case. And Michelle could tell you why.
Well, yeah, it was all about reading the language carefully, right? We didn't have anything that controlled ratites. We didn't have anything that controlled emus. And the way the language was drafted, it didn't say animals similar to, it just listed the animals, and so there was no regulation for emus. And so we lose. So that's why you need to read the language carefully.
That was the front page.
That was on the front page of the Daily Sun for a while.
Because the code didn't specify.
It had listed
a bunch of
animals.
Others, but there weren't there. Okay.
Yeah, and arguably they're like ostriches, they're livestock. And you know, it's really hard to prove one way or the other. It was funny, just Tuesday night, I was sitting in the council meeting and we're working on our animal code now, our animal keeping code. And we had this definition of livestock that talked about how the animals are raised for, you know, for like their wool or for food, or, you know, it listed 3 things. And then somebody got up and started talking about how, well, eventually these animals get older and they really convert from those uses to being pets. So I hurriedly wrote this email off saying, okay, we need to add that if the animal was once livestock, then it always remains livestock, because otherwise everybody's going to just call all of their livestock pets, and then we can't enforce our ordinance. So it's funny because it's really hard to think of these things when you're drafting, but then if you listen to people come up and talk about their situation, you can, oh, okay, I got to catch that. And you can fix things.
Yeah, you can't actually ever think of all of the possibilities. And you know, the big thing about exotic animals was actually peacocks, and that's what really requires the use permit, because they make so much darn noise. You can hear them for miles. So that's, I mean, usually where crazy codes come from is in reaction to crazy complaints and crazy things that people do.
Yeah, and being in a hurry.
Yeah.
So,
which we are all the time.
Right. So short-term rentals, this has been an issue that comes up so often now, right, with the Airbnb and all of that. And codes were written before Airbnb, almost all of them. And this was one of our issues, again, in Coconino County. It's easy to talk about the old stuff, right? While it's still going on, you kind of think, okay, I probably ought to wait until this is an old war story instead of a new war story. Anyway, so Coconino County had a code that had a series of definitions and then a section that talked a little bit about rentals. But the section where you'd think you'd go look to find the information didn't have a thing about short-term rentals. You had to read the definition of hotel, motel, and read the definition of a dwelling unit. You had to read like four definitions together. And if you did all that, you could get to the idea that short-term rentals were not allowed. You know, yeah, community development had just been kind of holding the line. Look, you read these 4 definitions, short-term rentals aren't allowed, so you have to stop that use. You know, it was time to fight it. Actually, Bill Ring, who now represents the county, instead was representing a private property owner. And he got, I don't know, 4 or 5 clients who you know, made a considerable amount of their living off of these short-term rentals of their property. And we had proof. We thought that they had been using them as short-term rentals because they put out ads on the internet, and you know, we printed the pages, thought everything was good. He argued to us that that was not sufficient evidence of the short-term rental. It just showed that they were willing to rent, but told us that we needed to actually prove that they were being used as short-term rentals, which, you know, with a small code enforcement staff, it's really tough. What are you going to do? Just kind of stalk that home and put people there and take pictures and, you know what the owners look like versus what these people look like? So that was one of the really difficult things about it is how do you get the proof? But then when we actually did manage to gather enough proof to bring the case, we presented it to the hearing officer. You know, I wrote this memo that I was really kind of proud of, you know, just kind of going step by step. If you read this, and then you read this, and then you read this is the answer. Couldn't be clearer. And the hearing officer just said, this is not how a code should be. This should not be so difficult that people can't figure out what their rights are in property. And so, therefore, it's allowed. And
really?
Yeah. So, you know, if we had appealed it, I don't know what would have happened, because you'd like to think that if your language says something that you can get there and eventually win. That's what we want to think as lawyers and what you guys need to think as planners when you're enforcing this. But it's tough when you make it so hard on your citizens. You know, you have to think about what that looks like then when the publicity comes about the case and that sort of thing. So we didn't appeal it, and I think times have changed now, and in some ways people are more tolerant of it because they're kind of hoping to do short-term rentals of their own places one day, or they go use them when they're on vacations.
The county now has a code.
The county has, they worked about a year on the ordinance, right?
Yeah, they did.
They
did after all this happened.
have an ordinance that regulates it, which is different than the city. We just don't regulate it.
And Sedona keeps going to court over and over on theirs. You can find reported cases from Sedona. They're really struggling with it. Of course, their community's facing a lot more of it than we do here.
But when you're a community, I mean, you know, part of what planners' beef is when you're in a desirable community that's a second, you know, it's a second home community. It's a way for people to afford to buy a second home. And so it really does and can change the dynamic of a community when neighborhoods are being bought out for short-term rentals. You know, have I necessarily seen that happen? Not as much. I was probably one of the staunch proponents of short-term rentals at the county, and the reason being is that I had been working on the Fort Valley area plan. Those people all live at the base of Snowball. They're going to be the community most affected. I highly think that Fort Valley will change based on the number of short-term rentals. They won't be the community that they once were. But with that being in mind, the longer and more time that I've spent with this and looked at it is rental structure really what we want to be regulating? Is that really a land use? Is how you rent your house or your business or your property, is that really what we're concerned about? And that conversation is also stretched over to student housing. Because of the way that we've been regulating student housing in the city, we do conditional use permit for rooming and boarding. I recently handled a case, actually somebody else took it before Planning and Zoning Commission for me, but in that case, when evaluating it, the only difference between it and a multifamily development was that we were regulating the rental structure. and we were requiring more parking spaces because they rented by the bed as opposed to by the unit. And it didn't fundamentally change at all, so now those arguments have been brought up. If we don't regulate the rental structure on single-family homes, should we be regulating the rental structure on multifamily homes?
So you'll have the opportunity to see that play out this year, because that's one of the things that our council will be considering the next few months. Roger Eastman, our code administrator, is bringing sections to of our code each week now to council, and he's done a great job of just framing the policy issues for the council members so they can come in, read the few questions they have to decide that night, and try to make a decision, give him input, and then he'll go back and finish the drafting. But one of the questions is, do we still want to regulate rooming and boarding facilities differently than multifamily homes? And I expect, if people are paying attention, we're going to hear a lot on it because of the student housing issue and concerns about parking and that sort of thing. And I think taking away a tool that allows the community to come out and talk about a conditional use permit may be very controversial and very hard to do, even though it seems completely logical. So we'll kind of see how that plays out.
There's logical and then there's political.
And you're also going to have the discretionary versus by right issue, aren't you, if you change the room and board thing?
Right.
Right, so that's
definitely
a big difference too.
Definitely. So I think that's all we brought, right? Yeah,
That was it.
that was all our stories. So you guys have questions for us?
How many cases do you work on go straight to sell? Is it the majority of them, or?
Yeah, when it's code enforcement, you know, by the time it gets to our desks, they've usually tried really hard to informally take care of it, so a bigger percentage of those actually end up going, you know, to court. There's often some kind of obstacle, like financial obstacle or philosophical obstacle. I think I was in court every other week at Coconino County with a code enforcement issue. I was just there a lot. And there were some that went on for years. You know, you'd go in front of the judge, and the people would kind of give their story about why they couldn't take care of their property, and the judge would say things like, well, can you call your children and get them to help you? And so we'd end up with these orders that would say things like, come back in a month after you've talked to your children. I mean, there's no other lawyering. Well, probably family law is similar, but like code enforcement, where you know, you just back and forth and trying to work it out. When it comes to like the big negotiations on development agreements, almost nothing goes to court. I mean, if lawyers get statutes that have head notes under it of all the cases that have gone up on appeal, and often there's like, you know, maybe 4 cases under a zoning statute because of time and money. We have to agree unless they think we're really wrong. And if they think we're really wrong and they have enough money, or they just have a lot of money, like the ranch guy, you know, we wanted to run the cattle through. I mean, I was kind of grateful for him in a way, because it's hard to get into court when you're a zoning attorney other than on code enforcement. So, you know, it's a good opportunity.
You brought some excitement.
Yeah, right.
Can you just explain essential nexes a little bit more? Essential nexes.
So in that original case,
You want to talk about the case?
well, so that original case, what it was is it was they had a cottage, they had a single-story little cottage, and they were going to tear it down and they were going to build a 3-story house. And so the city came back and said, well, you're going to totally block everybody's views and access, and so, well, you know, we'll allow you to go, I mean, it meets the height requirements, we'll allow you to go, but we want to have this path through, because now this visual access. So that is the nexus that they tried to make. It didn't work. So another example of nexus would be, your development is going to be the trigger that's going to need that intersection or need the signalized intersection. So you can show through the impact analysis there's a direct nexus. You're going to cause that impact.
But it gets more difficult as your project gets further and further away.
Yes.
Like recently, the city council decided that we would, as all of the city taxpayers would pay for widening the 4th Street Bridge, or at least a good amount of it, because you know how that kind of narrows and then goes back out again. Our original plan, consistent with what we do with everyone, is to have all the developers in the area of a certain size contribute money to that widening. Lots of the developments involved argued that it was not a sufficient nexus. Yeah, we're adding some people, but we're not adding nearly enough to have to pay for this widening. And we're way out here, and our people may go other directions. So, that's part proportionality argument, but it's also part nexus argument that we're just too far away.
Some are easier to make than others, for sure.
Yeah.
Okay, well, we're out of time. Thank you so much.